halt. You'll recall the conditions in the home were described as disgusting. The children, ranging in age.
Defendant seeks only limited sealing. That is the line buried in the motion filed in Benton County, Ohio. The father of 16 children removed from a house described by the state as a site of serious physical harm isn't asking the court to hide the charges. He is asking the court to lock away a document about his own mind.
Jr. is fit to stand trial. Attorney R. Lee Roberts has filed a motion asking Judge Rogers to allow him to file a motion request.
Think of a sealed evidence bag that contains not a weapon but a single sheet of paper. The paper is a competency evaluation request. The bag isn't kept shut to protect a legal strategy. It is kept shut because, according to the defense, the very contents are radioactive to a fair trial.
Gary Cers Jr. has been in jail in Southeast Ohio since June 30th. He's the father of the 16 children that sheriff's deputies and state.
Gary Cers Jr. has been in the Southeast Ohio Regional Jail since June 30th. He is 36 years old. The case involves 16 felony counts of child endangering against him alone. The accusation is not merely neglect. The statute specifies that abuse resulted in serious physical harm to the children, who ranged from a year and a half to 18 years old.
Parents, Gary Cers Sr. and Christina Cers, face the same charges. All four have pleaded not guilty. Now, the child endangering charge states that the children were abused and that the abuse resulted in serious physical harm. All of the children are in therapy.
His wife, Elizabeth Cers, faces the same charges. His parents, Gary Cers Sr. and Christina Cers, face the same charges. All four have entered not guilty pleas. But while the three other defendants remain physically present in the procedural machine, Gary Jr.'s attorney has just triggered a mechanism that could freeze the entire state's case against his client.
Requesting a competency evaluation under seal. That means we wouldn't be able to read it. Defendant's competency to stand trial has been raised, and the documents at
Attorney R. Lee Roberts filed a motion to file a request for a competency evaluation under seal. It is a specific legal maneuver. The motion for leave to seal argues that the documents contain highly sensitive mental health information, directly reflecting the defendant's psychiatric condition.
These documents contain highly sensitive mental health information or information directly reflecting defendant's psychiatric condition. The public disclosure.
The defense claims that public disclosure would unnecessarily invade defendant's privacy and compromise the confidentiality of competency-related proceedings. There is an immediate irony here. A case that began with a massive public breach, state agents entering a private home and removing 16 children, now pivots on the protection of a private psychological condition.
Psychiatric evaluation. Gary Jr. also faces 4 misdemeanor counts of public indecency. He's accused of exposing himself to someone on 4 occasions between May 23rd and May 31st at the home on Omer Street.
The court will have to balance that privacy against the visible record. Gary Cers Jr. also faces 4 separate misdemeanor counts of public indecency. The complaint alleges he exposed himself to someone who was not a family member on 4 different occasions in late May at the residence on Omer Street. This behavior, documented just weeks before the mass removal, offers a data point for the state's theory of a fractured reality.
Talk to me, if you would, a little bit about, first of all, this request. The attorney for Gary Cers Jr. is raising competency as an issue. Does that surprise you?
We consulted forensic standards to understand the mechanics here. A competency evaluation does not look backward. It doesn't ask if a person was insane during the commission of the crime. It applies a narrow 2-prong test to the defendant's present state.
2-prong test. We're looking at if the defendant is able to understand the nature and the objectives of the proceedings against them, and they're able to assist in their own defense. So if they are deficient in either one.
The first prong, does the defendant understand the nature and objectives of the legal proceedings against him? The second prong, can he effectively assist in his own defense? If he fails either one, the prosecution stops. The machinery of accountability freezes.
They're able to participate in the process and do so in a way that's effective for them.
You know, earlier we showed a clip of Gary Jr. in court, the judge during the.
However, there is an audio-visual contradiction already sitting in the court record. During Gary Jr.'s initial appearance before Judge Rogers, a specific exchange was captured. When the judge began reciting the possible pleas, Cers did not simply stand mute, he verbalized a distinct cognitive request. He asked to confer with counsel before entering a plea.
Stand those pleas. How do you plead? Can I speak to a lawyer first?
Yes, I will enter a not guilty plea for you at this time then, and you can confer with counsel.
So
Judge Rogers asked, "How do you plead?" The defendant replied, "Yes, I will enter a not guilty plea for you at this time then, and you can confer with counsel." The procedural outcome was a not guilty plea entered on his behalf, but the behavioral evidence is the interruption itself. He knew enough to know he didn't know what to say.
So that right there shows me that he understood enough to actually ask for a lawyer. He wanted to consult with an attorney. What does that tell you about his potential competence here?
I don't know.
This presents a cognitive dissonance for the competency argument. On one end, the ability to invoke a right suggests a functional understanding of the courtroom roles, knowing the judge is not your advocate. But forensic analysis suggests caution. It may simply be a primitive survival reflex, a biological signal to ask for help, not proof of a rational understanding of complex felony procedure. Knowing you need a life raft isn't the same as knowing how to steer the ship.
For so long. Now, here's the one thing that I think our viewers have to keep in mind. A competency hearing or a competency determination is not the same as insanity. And a lot of people will confuse the two. So the competency, why it makes sense here is because it's to gauge whether or not at the current time. So it doesn't look back really.
This is where the timeline tightens into a thriller. The competency process examines the man's mind right now, but the charges span years. The crimes began by logical necessity almost 2 decades ago when the first children were born. The house became a closed system. The children were largely off the radar.
He must be competent because this family knew how to evade detection. They knew how to hide. They weren't in school. How were they living? Nobody applied for social services. Do you do that on purpose?
There is a brutal counter-argument that arises from the evidence of evasion. To maintain a sealed environment for 16 children across 2 decades, to dodge mandatory reporting, school enrollment, and state surveillance, requires a functional criminal logic, so the ticking clock question becomes, if the defense proves he currently lacks the mental capacity to stand trial, does that mental state also explain a 20-year pattern of organized concealment?
So that you can live like wild animals. I'm sorry to say it, but that's kind of how they were living. The reports are when the police finally got to this family, a lot of the children couldn't speak. They couldn't.
Because the state doesn't just need to prove the conditions were disgusting, they need to prove intent and responsibility. Reports indicate that upon discovery, many of the children could not speak or write their names. This suggests a deprivation so profound it transcends simple neglect.
Child endangering, but how many more and who gets indicted for what? That's still an outstanding question.
We are still at the complaint phase. Preliminary hearings were waived. No grand jury indictment has been unsealed yet. The charges could multiply, or the evidentiary weight could shift. But right now, the single manila folder containing the sealed mental health evaluation holds more power than the warrants.
He's incompetent and not restorable, then at some point he may be committed civilly to a psychiatric hospital if the court believes that he's guilty of the crime by clear and convincing evidence and he's still a danger to the community, that he could be committed to a psychiatric.
The stakes are absolute. If found incompetent but restorable, Cers could be committed for up to a year to see if medication or treatment can bring him back to a point where the trial can proceed. If found incompetent and not restorable, the state faces a chilling possibility, a civil commitment ceiling that effectively neuters the criminal docket.
Mental health condition and competency evaluation. No less restrictive alternative would adequately protect the confidentiality interests at issue.
The defense argues no less restrictive alternative than sealing the record exists. The state is silent on the motion for now, but the public record already knows the central betrayal.
The only update we have on the children is that they're in therapeutic foster care. We don't even know their exact conditions, and maybe we shouldn't know that as the public because it's health information. It's protected by HIPAA, but it would be nice to receive some sort of update.
Nobody asked. Nobody answered.
It's going to be such a long road for these kids, and probably even worse for the older ones. I think the oldest is 18 years old. And if that child lived, since we have no records, like some of them, so if that child lived his or her entire.
We end with the 16 children now in therapeutic foster care. Their health records are protected by privacy laws, just as the defendant's mind is now being shielded. They are the ones who will have to learn to read, write, and speak a language that was denied to them, perhaps for their entire lives. Their recovery timeline is measured in decades. The competency evaluation will likely take 2 or 3 hours on a single afternoon.
How long does that take, that evaluation? Is that something that can be done, in an afternoon? Does it take a couple of meetings with a defendant?
Usually,
Nobody asked, nobody answered.
Jr. remains in the Southeast Ohio Regional Jail on a $300,000 bond. His wife, Elizabeth, the mother of the children, and his mother, Christina Lynn Siders, also remain in jail. Their bond is also $300,000. We're going to keep a close eye on this and let you know what happens. That's it for this episode of Crime Fix. I'm Anjanette Levy. Thanks so much for being with me.
I'm pointing you to the docket of the Benton County Court of Common Pleas. Find the motion for leave to plead filed by the defense for Gary Cers Jr. Read the language protecting the competency documents. Here is the question to answer in the comments. If the evaluation reveals a condition that existed for 2 decades, does that exonerate the system that never looked for these children, or indict it? I'll see you back here for the next filing.